What inspires change? What motivates us? It's what's inside that moves us. What moves you? Get the Scion story at scion.com.
Attorney Julian Uggan and his client, Dr. Ann Hattori, have filed a brief opposing Dave Davis's appeal of his earlier lawsuit on the Guam plebiscite. Davis has asserted that the Guam plebiscite, or the vote for self-determination, is based on race. That is, that it only allows people of a certain race, namely Chamorros, to vote on Guam's political status, a vote also known as self-determination. This suit was dismissed by District Court Judge Francis Tidinko Gatewood. Davis then appealed the case in the Ninth Circuit Court of Appeals. Uggan and Hattori have now entered this case as a friend of the court and are siding with Tidinko Gatewood's decision to dismiss the case.
In our brief, we make it clear that the native inhabitants of Guam's statutory definition is facially race neutral. On its face, the statutory definition of native inhabitants of Guam has nothing to do with race. It basically posits that anyone who gained their U.S. citizenship through the operation of the passage of the 1950 Organic Act of Guam qualifies under the statute's definition.
Right now, the plebiscite, or vote for political status, only allows native inhabitants of Guam to vote. However, the definition of native inhabitants of Guam includes anyone who was or is descended from someone living on Guam before or on 1950 who received their U.S. citizenship via the Organic Act of Guam. Uggan says that it will be difficult for Davis to prove that the vote for Guam's political status is based on race.
The U.S. Supreme Court has consistently held that a disparate racial impact by itself is not enough to trigger a constitutional violation under either the 14th or the 15th Amendments. By itself, a facially race-neutral statute is not enough to trigger a violation of the Constitution. Davis is, under the law, required to specifically prove that the Guam legislature specifically intended, by enacting the Guam Decolonization Registry statute, to discriminate along racial lines. And here, the statute clearly exhibits a non-race-based intent. And that fact alone will prove fatal to plaintiff's case. He's going to fail under Washington versus Davis, Personal Administrator of Massachusetts versus Feeney, Arlington Heights, City of Mobile, Alabama versus Bolden. These are all decisions that basically uphold the general rule that unless plaintiff can successfully first prove that the challenge statute was enacted with specifically racially discriminatory intent, he cannot prevail on his constitutional challenges.
Uggan also points out that even if it is found to be race-based, it's the U.S. Congress who defined native inhabitants of Guam, and the Guam legislature merely adopted the federal statute with their local law. The vote for Guam's political status has often been referred to as a Chamorro-only vote, but Uggan says this is not true.
The statute that Davis challenges in this case doesn't even use the word Chamorro in it. It actually uses the term native inhabitants of Guam, which is on its face completely neutral as to race. It only concerns U.S. citizenship and timing. So whoever was here and gained their citizenship by virtue of the passage of the 1950 Organic Act of Guam does qualify as a native inhabitant of Guam. So the word Chamorro only is just a good example of how we sort of don't use words precisely.